Hello, this is R.J. Deacon, reading the Supreme Court of the United States opinion syllabus in Texas versus New Mexico, on motion for review of the River Masters final determination. If you'd like to support the podcast, please stay tuned to the end. And if you're new to the podcast, this is probably not the Texas Supreme Court case you're looking for. This was argued October 5th, 2020, decided December 14th, 2020. The 1949 Interstate Pecos River Compact provides for equitable apportionment of the use of the Pecos River's water by New Mexico and Texas. In a 1988 amended decree in this case, the court appointed a river master to annually calculate New Mexico's obligations to Texas under the compact. See Texas versus New Mexico. The court also adopted the River Masters Manual, which elaborates on how to make the necessary calculations to determine whether New Mexico is complying with its obligations under the compact. As relevant, Section C.5 of the manual provides that when water is stored at the request of Texas in a facility in New Mexico, then New Mexico's delivery obligation will be reduced by the amount of reservoir losses attributable to its storage. In 2014, a tropical storm caused heavy rainfall in the Pecos River Basin. To prevent flooding, Texas's Pecos River Commissioner requested that some of the river's water be stored in New Mexico. New Mexico's commissioner agreed. Several months later, the water was released. But critically, for purposes of this dispute, a significant amount of water evaporated while the water was held in New Mexico. For years thereafter, the states sought to reach an agreement on how the evaporated water should be accounted for under the compact. To permit those negotiations to continue, the River Master outlined a procedure in 2015 that called for the future resolution of the issue. Neither state objected. When negotiations eventually broke down, however, New Mexico filed a motion with the River Master that sought delivery credit for the evaporated water. As relevant here, the River Master ruled in New Mexico's favor, rejecting Texas's argument that the motion was untimely and concluding that the evaporated water was water stored at the request of Texas under Section C.5 of the River Masters Manual. The Supreme Court held, Justice Kavanaugh delivered the opinion of the court. New Mexico's motion for credit for the evaporated water was not untimely. Both parties agreed to postpone the River Masters' resolution of the evaporated water issue. Neither party may now object to the negotiation procedure outlined by the River Master for resolving the dispute. New Mexico is entitled to delivery credit for the evaporated water. Section C.5 of the River Masters Manual resolves this case. Texas requested that New Mexico store water at a facility in New Mexico, and New Mexico did so, with the understanding that the water belonged to Texas. Texas's counterarguments that the stored water was not actually part of the Texas allocation referred to in Section C.5, that New Mexico did not store the water for Section C.5 purposes, and that Texas should not be charged for any evaporation occurring from March 15th until the water was released in August 2015, are unpersuasive. The motion is denied. Justice Kavanaugh delivered the opinion of the court, in which Chief Justice Roberts and Justices Thomas, Breyer, Sotomayor, Kagan, and Gorsuch joined. Justice Alito filed an opinion concurring in the judgment in part and dissenting in part. Justice Barrett took no part in the consideration or decision of the case. Thank you for listening. If you'd like to get a hold of me, I can be reached at rhodesscholar80@gmail.com. That's Rhodes like the truck driving Rhodes and 80. And if you'd like to support the podcast or support me as I slog through law school, please find the podcast on Patreon or follow the PayPal link in the show notes.